Acosta, our next speaker. Dr. Juana Acosta is the director of the Legal Clinic of Public Interest and Human Rights at the University of La Sabana in Colombia. She spoke at our Mexican conference, and she is a lawyer from the Javeriana University of Colombia. She holds a master's degree in human rights and democratization from Externado University, a lawyer's degree in international legal studies from New York University, and a PhD from the National Autonomous University of Mexico. She serves as the Director of Social Projection and Relations for Law and Political Sciences faculty at the University of La Sabana in Colombia. And the title of her talk is Present and Future for the Protection of Life at the International Level, Challenges and Opportunities. So would you please give a very warm welcome to Dr. Juana Acosta. Thank you very much.
Well, hi to you all. It is an honor and a privilege to be here. And it is very difficult to speak after Isabel, because I think it's so impressive, and thank you very much for her testimony, and thank you all also for what you do. And I also want to thank, I'm very grateful to Sean, to Robert, to Tomislav, to Matt, to Pamela, to Laura, for this invitation. It not only allows me to meet so many wonderful people doing admirable work in the protection of life, but has also afforded me the opportunity to come to Rome, a city I have long wished to visit and love so much. As Saint Jose Maria said, the church is Roman, Roman, Roman. So truly, thank you very much. Moreover, this Congress offers me the unique opportunity to visit the tomb of San Pio de Pietrelcina, to whom I have specifically entrusted the Beatriz case. Thus, as you will learn in more detail later, this case is among the most challenging, involving critical issues related to the protection of unborn life. Having represented the Central American state of El Salvador in this case, I brought with me to the court a first-degree relic of Padre Pio. And the experience was truly remarkable. There were many miraculous occurrences, many. And I look forward to sharing those stories with you during one of our breaks. I would also like to apologize in advance for my English, and please feel free to interrupt me and ask me anything if there's anything you don't understand. And I will rely more on reading to provide more clarity, and also if you don't like something I say, blame the jet lag, not me. I do not take full responsibility for my words. Can we put the, thank you. So, I don't know if some of you remember 1984's George Orwell book, and if you remember Newspeak. This was the new language that the totalitarian regime created in order for people to not say a lot of words. There were a lot of words that were censored, and the language was completely changed. And the book shows how this was precisely because they didn't want people to think, to even think about certain words. And language is so important, and I'm going to speak about this in international law, because as you can see today, nowadays, there are a lot of words that are being censored, and a lot of words that are being promoted. And it's terrible because, as you can see, many of us cannot speak more about abortion killing babies. But now, in many national and international laws, we have to speak about voluntary interruption of pregnancy. As this is something we interrupt, and you can afterwards save, which is completely false. And this change of language basically has the potential in culture in changing completely minds and hearts. You can see young people completely convinced that you can interrupt a pregnancy, that there is no life in the womb, and this is because of the change of language. Also, you cannot talk about euthanasia today, you have to speak about the right to die with dignity. That's completely crazy in our language. Also, you cannot speak about female genital mutilation. You have to speak about gender affirmation surgery. This is just a few examples of language changing in our culture and changing minds and changing hearts. And this is exactly what is going on in international law, and this is what I'm going to speak to you about. So when you hear my conference, bear in mind that although international law is going there, of course, we have to fight that language, and we have to speak the truth. Because God tells us to speak the truth, and it is difficult nowadays to say, this is not true. There is no right to die with dignity when we speak about euthanasia. There is not interruption voluntarily of a pregnancy. It goes so far, I don't know if you remember this, but when the Scots overturned Roe versus Wade, there is like a word puzzle in the New York Times, and the day after, or 2 days after Roe versus Wade was overturned, the correct word of that puzzle was fetus, which was like basically God telling, this is who you want to protect. And sadly, the New York Times reaction was this. They eliminated from the word puzzle the word fetus, saying that it was only casual, that it was not their fault that fetus was the word in the puzzle, and again, trying to make unthinkable what we have to defend. Yesterday, Sean was telling us that what's going on with abortion is unthinkable. Sadly, they are trying to literally make it unthinkable. Literally make it unthinkable for people to think about the baby in the womb. You can imagine what would happen if it was not fetus, but baby. It could be like a lot of words, right? So in this presentation, I would like to provide you with an overview of the past, present, and future of the protection of life in international law. In the past, I will present the background of the recognition of the right to life in international law and its milestones in its protection. In the present, I will discuss what is currently established by European Universal and Inter-American System of Human Rights. And finally, regarding the future, I will address some pending cases and opportunities for pro-life organizations worldwide. As you will see, the outlook is not very encouraging, but this calls us to fight more intensely, to defend our principles and values, and to keep hope alive, as Isabel was saying, because we know that the Lord has already overcome. We already won this fight. So let's explore what I refer as the past, reflecting the true content of treaties concerning the protection of the preborn life. As we will discover, interpretations have significantly and sadly altered the original meaning, but as I said, we have to fight to preserve the true content of the protection of all human beings. In international law, the right to life is acknowledged for all members of the human species, implying that the unborn are also necessarily holders of this right. While this may sound seemingly obvious to all of us here, normally I don't have these friendly audiences, so here it is obvious to us, the reality is that not only is this still a subject of debate, but it also seems to be increasingly blurred, to the point that in some countries this recognition is on the verge of disappearing altogether. To understand this point, it is essential to consider that the Convention recognizes the right to life for every person. And the same text specifies that for the purpose of the Convention, the term person refers to every human being. This implies that every human being is entitled to the right to life. It is scientifically proven that embryos and fetuses of the human species in gestations are, of course, human beings. Therefore, it is evident that in the light of the American Convention, the unborn, being human beings, are entitled to the right to life. Furthermore, there are binding instruments that expressly recognize the entitlement of rights to the unborn, including, of course, the right to life. This arises from logic, because it is contradictory to assert that the unborns are holders, for example, of the right to equality, without first protecting the right to life, the right which no other rights can be enjoyed. Thus, Article 4 of the American Convention establishes that the right to life will be protected from the moment of conception. From the moment of conception, that is the text. And the preamble of the Convention on the Rights of the Child emphasizes the need for legal and non-legal protection of the child before and after birth. Don't let anybody tell you that international law does not expressly protect the unborn. In addition to the norms I have already mentioned, there are other binding instruments, and when I mean binding, they are binding to states, that establish the entitlement of rights to all members of the human species, including the unborn. Furthermore, these instruments enshrine the obligation of non-discrimination. This is highly relevant because denying the entitlement of rights to an individual only based on their age is discriminatory and therefore contrary, of course, to international law. In particular, the preamble of the International Covenant on Civil and Political Rights recognizes that all members of a human species have inherent dignity and equal and inalienable rights. Similarly, Article 2 of the European Convention on Human Rights states that no one can be deprived of the right of life. Lastly, once again, the American Convention on Human Rights establishes that the essential rights of men are not derived from being national of a certain state, but have as their foundation the attributes of the human person, which is why they justify international protection. The recognition of the right to life in international law implies that states are called upon to protect, promote, and guarantee this right for all human beings. It is indisputable that in every pregnancy, there are two human beings entitled to rights, the woman and the unborn baby. Therefore, in addition to ensuring the right to life of the unborn, the state must also guarantee and respect the right to life and integrity of the woman, of course. Of course, we cannot ignore that although not in all cases, in some exceptional, today truly exceptional instances, these rights may come into conflict. Nevertheless, such protection must adhere to criteria of equality and consideration in each case, mainly to the double effect principle that Pilar was telling us before, and always trying to save both lives. And failure in this protection could lead to the international responsibility of the state. From the above, it is clear that a review of various international treaties can lead to the conclusion that the unborn is entitled to the right to life, and consequently, states are obliged to respect, protect, and guarantee that right, no matter what national legislation say, precisely because states have signed and ratified these treaties that protect unborn life. Now, there is indeed one international treaty that recognizes access to abortion as an international obligation, very sadly. This is the Maputo Protocol, specific to the African human rights system, which states that the state parties must take all appropriate measures to protect the reproductive rights of women by authorizing abortion in case of sexual violence, rape, incest, and when continuing the pregnancy would cause harm to the physical or mental health of the mother or the life of the mother of the fetus. As you see, it's very broad. However, on the one hand, unfortunately from this, this is, of course, unjust law. As Matt will tell you afterwards, no one is obliged to obey unjust law. But on the other hand, from this protocol, we cannot infer that there is a right to abortion in international law. Some people argue this, that is a right to abortion in international law because the Maputo Protocol obliges African states to access to abortion, and therefore that it is mandatory for states to guarantee it. This protocol is optional, meaning it applies only to the states that ratify it and not to the entire African system, much less to states outside the system. Unfortunately, 44 out of 53 member states of the African Union have ratified this treaty. Nor does the protocol give rise to a trend of creating like a customary norm that would compel states to guarantee abortion. While 44 states in the world are parties to the Maputo Protocol, 173 states are parties to the International Covenant on Civil and Political Rights, and 196 states are parties to the Convention of the Rights of the Child, both of which recognize the entitlement of rights to the unborn, including, as I said before, the right to life. Now let's delve into some of the most emblematic cases. As I said before, the outlook is not very encouraging. Nevertheless, again, it is crucial to bear in mind that Christ has already triumphed and that he beckons us to be a source of light amidst the prevailing darkness. There are at least 15 emblematic cases regarding the protection of the right to life in international law. The first of these is the case Patton versus the United Kingdom. Maybe it says Reino Unido, the United Kingdom, in 1980, before the European Commission of Human Rights. In this case, a father sought a court order from the High Court to prevent the mother from having an abortion and argued that he was not consulted in the abortion authorization process. The Commission ruled that Article 2 of the European Convention, which enshrines the right to life, applies only after birth and does not protect the unborn. Additionally, the Commission stated that the father had no right to be consulted. This is international organs completely manipulating the law. I would like to emphasize the following problematic considerations made by the European Commission. According to this body, the term person and life in Article 2 of the Convention apply only after birth. This interpretation, of course, disregards the fact that it is absolutely clear the existence of human life before birth. Second, the authorization of abortion is protected considering only the protection and health of the woman. The truth is that in that decision, the Commission does not conduct an exhaustive assessment on how the pregnancy could affect the life of the mother or why abortion was, according to them, truly necessary. The Commission acknowledges that the abortion interfered with the father's right to family life, but without further justification, it considered that this interference was necessary for the protection of the rights of another person. This disregards the international treaties that affirm that so-called sexual and reproductive rights belong not only to the woman, but to the couple. This is also something that you have to bear in mind. International treaties says that supposed sexual and reproductive rights are not only of the woman, are of the couple. So yes, the father has something to say in every time a woman wants to abort. Therefore, it is troubling that the Commission considered that the husband's and potential father's right to respect for their private and family life does not imply the right to be consulted or the right to submit requests regarding an abortion that his wife intends to undergo, as the will of the pregnant woman takes exclusive precedence. It is particularly important to note that in its consideration, the Commission referred to the American Convention to emphasize that this instrument does indeed enshrine the protection of the right to life from conception. However, it considered that there was a great divergence of ideas on the question of when life begins. Later, in 1981, the Inter-American Commission on Human Rights considered the case Baby Boy versus United States. In this case, it was alleged that the right to life of a fetus was violated as an abortion was performed, and the conviction of the doctor who had performed it was annulled based on the issues of the Roe versus Wade and Doe versus Bolton decisions of the United States. The Commission decided that the right to life had not been violated because the American Declaration does not protect this right for the unborn. According to the preparatory documents of this instrument, although there was a consideration to expressly include the protection of life from conception, it was decided not to do so, considering the impact on the legislation of states that allow abortion at the domestic level. Then in 2002, the European Court of Human Rights heard the case Bosso versus Italy, where a pregnant woman decides to have an abortion against the opposition of the father of the fetus. The plaintiff is the father, again, who argued that the abortion deprived him of his right to be a potential father and the fetus of its right to life. Furthermore, similar to the case Patton versus United Kingdom, the father questioned the unconstitutionality of Italian legislation that allow women to unilaterally decide whether to have an abortion or not. On this occasion, the position of the European Court was not very different from that of the Commission in 1980. The court considered that there was no violation of the right to life, given that the abortion had been performed in accordance with national legislation, which did not contradict the convention since it was a matter that was within the scope of the state and was necessary to protect the health of the mother. Additionally, it considered that the right of the potential father to respect for his private and family life cannot be interpreted so broadly as to encompass the right to be consulted or to request from a court an abortion that his wife intends to undergo, as the rights of the woman must always prevail. As the last milestones from the past, in 2004, the European Court of Human Rights heard the case VO versus France, where due to a medical error, an abortion was induced without the mother's consent. In this case, the court considered that the non-application of the crime of homicide to the unborn did not constitute a violation of the right to life, as there were other effective remedies available for obtaining redress domestically. The court did not define whether the unborn has the right to life or not. Then in 2005, the Human Rights Committee heard the case KL versus Peru. In this case, the life of the mother, a 17-year-old young woman, was supposedly at risk, and the unborn baby was diagnosed with anencephaly. In this instance, the committee considered that the failure to perform the abortion, hear me right, constituted torture for the woman. This is also a change in the language that is very problematic. International courts are saying that obliging a woman to carry her baby until the end is torture under international law. Subsequently, in 2007, the Inter-American Commission on Human Rights heard the case Paulina versus Mexico, in which a 14-year-old girl became pregnant as a result of sexual assault. The state acknowledged responsibility for not providing an abortion, recognizing the violation of her sexual and reproductive rights. Then in 2007, the European Court heard the case Tysiak versus Poland, in which a pregnant woman with severe myopia was informed that pregnancy and childbirth could seriously affect her vision. She requested an abortion, however, her request was denied. The court considered that the denial of the abortion constituted a violation of the right to private and family life of the woman. In 2009, the European Court heard the case Women and Waves versus Portugal. In this case, an organization entered Portuguese waters to promote the decriminalization of abortion. The state sent a warship to request withdrawal, arguing the prohibition of the promotion of illegal activities. At that time, abortion was illegal in Portugal. The court considered that the right to freedom of expression was violated when information about the decriminalization of abortion was not allowed. This is a case that we can use also on our side for freedom of expression. It's very important for us also to use these cases, because if they can speak loud and they can say decriminalization of abortion is supposedly a right, where we can also say that we must protect human life of the unborn and we have to defend our freedom of expression. In 2010, the European Court took jurisdiction over the case ABC versus Ireland. 3 women reported having to travel to other countries to have an abortion due to the prohibition in Ireland. In its decision, the court considered that pregnancy and its potential termination not only concerned the woman's rights to private life, but are also linked to the development of the fetus. The court decided that the state was not responsible for the alleged violation. This is also a case that it's a little, it means a little bit of hope, specifically because the European Court respects a little bit more than the inter-American system, national legislation. That is why we have to, especially in European countries, fight to change national legislation, fight to change the constitution and the law, because in some cases the European Court has said that we have to respect national law, even of course if that national law is a restriction on abortion. You will hear that all the other cases I'm going to speak about now refer to that exact point of view, which is different from the past. In 2011, the case LMR versus Argentina, the UN Human Rights Committee heard the case of a woman with a disability who asked for an abortion, and the law allowed for the procedure. The committee considered that denying the practice of an abortion when domestic law allows it constitutes a violation of the right to private life. Then, returning to the European jurisdiction, in 2011, the European Court heard the case RR versus Poland, where a pregnant woman with a fetus alleged to have abnormalities was denied an abortion. The girl was born with Turner syndrome. This is not, of course, life-threatening. It's just a disease. The court considered that denying a request for an abortion when the domestic law of a state allows it constitutes a violation of the right to private life. Same thing happened in case LC versus Peru, where a woman who was victim of rape requested the abortion and it was denied, and the committee said that when national law allows abortion, they violate international law if the woman has not access to abortion. In 2012, discussions of the right to life of the unborn reached the Inter-American Court of Human Rights through the case Artavia Murillo versus Costa Rica. In this case, 9 couples claimed the violation of their rights because in vitro fertilization was not allowed in Costa Rica. Taking the case further than required and exceeding its mandate, first, the court interpreted that the term conception, enshrined in Article 4 of the American Convention, which is perfectly clear, it says conception, but the court says, no, no, no. Actually, it's not conception. It is implantation. So we are going to interpret that when the Article 4 says conception, we really mean implantation. Second, it considered that the protection of the right to life is not absolute, but rather gradual or incremental, according to the development of the human being. This is our court in the Americas. I'm not proud of it. In 2012, in the case PNS versus Poland, the facts relate to a pregnant woman apparently as a result of sexual assault. In a hospital, conscientious objection was claimed, and the abortion process was delayed for various reasons in the healthcare system. On this occasion, the court considered that the right to private life and the prohibition of torture, cruel and inhuman or degrading treatment were violated, not due to the general prohibition of abortion, but because, despite decriminalization, the state had not provided the necessary mechanism for the procedure. And in particular, because there was no clear information about access to abortion. Thus, in this case, the European Court reiterates that the obligation for states regarding abortion only become enforceable when the legislature has decided to decriminalize it. Finally, in 2016, in Advisory Opinion 2216, the Inter-American Court of Human Rights determined that for the purpose of the American Convention on Human Rights, the terms human being and persons are synonymous. This is a great case for us, although this was not an advisory opinion about abortion. So the court did this without knowing this was going to impact abortion, because this advisory opinion was about the protection of legal persons in the states. But the court said this, and this is of particular importance concerning the protection of the right to life, as it implies that the unborn, as human beings, are also holders of the right to life. We use this a lot in our litigation in the inter-American system. Precisely, Article 4 of the Convention recognizes the right of all persons, in other words, all human beings. So from these cases, I would like to highlight the following conclusions. Only in the inter-American system has it been made clear that the unborn is a holder of the right to life, although in a gradual and incremental manner, which is terrible, of course, but at least there is a recognition, and textual and express recognition of the court. In the universal and European system, it has either been considered that there are no holders of this right, or the discussion has been avoided, or just what the state says is the protection in every case. In the universal system, the European system, and the inter-American system, state responsibility has been demanded only when states have recognized the internal authority to perform abortions. However, it has not been suggested that there is an international obligation to guarantee abortion or decriminalize this conduct, although we will see that now that is the path. And the Maputo Protocol is an exception in the African system. However, as mentioned, this is only an optional instrument, so it only obliges those who sign it and applies only to states in the African system. And again, we are never obliged to obey unjust law. Now let's discuss what I term as the present, referring to the current interpretation of international bodies. Unfortunately, through an overwhelming amount of misinformation and manipulation, these bodies have been advancing non-binding decisions. This is not treaties, not courts. These are non-binding organs, just political organs, with statements in an attempt to establish an international obligation to recognize unrestricted, accessible, and on-demand access to abortion. Here we see that in 2016, the United Nations Committee on Economic, Social, and Cultural Rights made observations regarding the right to sexual and reproductive health. In those observations, it expressed that the obligation of states to repeal or amend laws that seeks to penalize abortion or restricted laws in this regard. So the committee is telling states that they have to decriminalize abortion. This is a UN committee, a United Nations committee. Additionally, states were urged to take measures to prevent abortions under risky conditions. Then in 2022, this is just like 2 years ago, the Committee Against Torture, in its concluding observations on El Salvador Third Periodic Report, urged the state to take measures promoting the decriminalization of abortion. The committee recommended ensuring full and effective access for women and girls and preventing both patients seeking abortion and medical professionals performing it from facing any criminal sanctions. Similarly, in 2023, the Committee on the Elimination of Discrimination Against Women, on the International Day of the Girl, which is, I don't know what to say, dedicated part of its speech to discuss the importance of access to abortion for girls and adolescents. You know, this is like the topic in UN committees. There are a lot of things going on in the world, a lot of violations of human rights, but the Committee on Torture, the Committee on Economic, Social, and Cultural Rights, the Committee of the Violence Against Women, they are all speaking all the time about abortion, about abortion, about abortion. It is so clear that evil is like basically going so hard on these committees. It is so evident, so evident. They defined it as a crucial aspect for girls and a human right at the international level, referring to the International Day of the Girl as the perfect opportunity to ensure that girls do not have to face unwanted pregnancies and can have abortions to avoid, hear me, to avoid social and economic consequences of pregnancy. The committee went so far as to state what no international body had dared to say until then, that abortion is a human right. So we now have the UN Committee on the Violence Against Women and Girls saying that abortion is a human right. Do you remember what I talked to you about Newspeak? This is going so far as to say abortion is a human right. This is completely opposite. No? Human rights, abortion, like completely opposites. And then this committee is recognizing this. And it's where courts, international courts, are trying to go. Now, I would like to share a case that we advocated for from the legal clinic I lead in Colombia, where we thought about how to navigate narratives. We were speaking with Matt this yesterday. How to navigate narratives and cases that help us to protect our principles and values in context with completely adverse laws and courts. In this case, Sarah is a woman who, due to an illness, cannot conceive naturally. In September 2020, Sarah and her partner decided to undergo in vitro fertilization. The relationship ended, but Sarah chose to continue the in vitro fertilization treatment based on a clause in the informed consent, stating that in case of separation or divorce, the fate of the cryopreserved embryos should be determined by the mother. However, the clinic and the doctor refused to continue the process, claiming that Carlos, because if you want to protect life, the voice of the father does count, no? But if you want to kill the baby, the voice of the father doesn't count. So in this case, Carlos' voice was very important for the clinic. And because Carlos withdrew his consent, they should not do the implantation of the embryo. Of course, we are completely against in vitro fertilization, but there was a life now. Only one surviving embryo, masculine embryo, so we should protect that embryo, and we should implant that embryo, no? This case reached the Constitutional Court in Colombia. The Constitutional Court sadly did not recognize the embryo's personhood. We asked the court to recognize the embryo's personhood based on Artavia Murillo versus Costa Rica. So the court said, because the Inter-American Court says that the embryo is not a person, we are not going to recognize the embryo as a person. Where it was considered that conception was implantation, as you remember I told you. However, the court acknowledged that there are less harmful avenues in cases of unwanted paternity and ordered the embryo transferred to Sarah's uterus. So we managed to save that life in this case. Basically, the court had to contradict herself if the court basically advised for the word of the father, right? So they couldn't do it. And they had to protect the embryo. And we managed to protect this life. Thus, thank you. No. It determined that Carlos' right to decide not to be a father lacked sufficient weight to oppose Sarah's claim. No? However, and this is very sad, Carlos still had the option to decide whether or not to assume the paternal bond on the events of the embryo's implantation and pregnancy leading to the birth of the person. So he might not be a father. Additionally, the Constitutional Court ordered, this is very important, ordered the Congress to regulate assisted reproductive techniques. As we managed to demonstrate how problematic these procedures are from a bioethical point of view, and how dangerous the gaps in this matter can be in a country. Now we are basically discussing this law in Colombia according to the order of the Constitutional Court. Lastly, I want to delve into what I refer as the future, highlighting the pending decisions that will shape our ongoing struggle in the coming years. Once more, the landscape appears increasingly challenging, but we hold firm to the knowledge that God's powers prevails in such scenarios, albeit not always on a preferred timeline. We would like everything to be changed now, but remember, Roe versus Wade was overturned after a lot of years of fighting and perseverance, and that's what we have to do. As I told you at the beginning, one of the upcoming challenges is the verdict in the case Beatriz versus El Salvador, which is set to be decided this year by the Inter-American Court, where we represent the state of El Salvador defending the right to life from conception. This is one of the only states in America that still protects life from conception. Beatriz suffered from lupus erythematosus and became pregnant with her second daughter, who was diagnosed with anencephaly. The petitioning party argued that Beatriz should have undergone an abortion because continuing the pregnancy posed a threat to her life. Thus, this was not true. Pro-abortion organization managed to convince Beatriz that she was going to die if she didn't have an abortion, and she was truly convinced that she was going to die, but this was not true. By the medical records, was not true. She actually died 4 years later. She had her baby. Her baby was called Leiliani. She named the girl. She only survived 5 hours, but she named her Leiliani, and she survived perfectly in the pregnancy. She died 4 years later of a car accident, and the petitioners are trying to blame El Salvador for her death 4 years after in a car accident, claiming that there is a causal nexus between denying the abortion and her death 4 years later because she was very weak, because she was depressed, and because she didn't manage well with her illness, and that got her to death. That's the claim in the International Court. That is where they go when they try to claim abortion debates in these courts. I want to highlight the following 4 risks or challenges of this case in the Inter-American system. There is a central risk in this litigation, which is that the Inter-American Court of Human Rights establishes, through interpretation, the existence of a right to abortion, as the Committee of the Women said before of the UN. That is the allegation. Another major challenge in this case is the narrative of the victim representatives and the Commission. Beatriz's daughter is completely ignored, and her life is left in absolute vulnerability, considering any protective measures for her life. In the hearing at the court, it was impressive. We as representatives of El Salvador say to the court, no one named her. Everyone talked about Leiliani, the girl that was born, because she actually was born and lived for 5 hours, and the commission and the petitioners and the judges of the court referred to her as the product of conception. At most, as the fetus, never a girl that was born. And this is the second case that this happened. Also in another case, Manuela versus El Salvador, the court, all the time completely ignoring there is a life. There is another life. Finally, this case jeopardizes other rights, such as conscientious objection and freedom of expression, because one of the things that is involved there has to do with, this is not part of the case, not at all, but the court is going to say that conscientious objection, if the claims are accepted by the court, she's going to say that conscientious objection is not a right, but an obstacle, which is something that all the UN committees are also saying, that this is not a right, this is just an obstacle for the access to abortion. The very dangerous thing is that all these risks can be materialized in the concept of what the court calls the conventionality control, where the states must assess the compatibility of their national norms with the text of the convention. As different from the European Court that respects national law, the Inter-American Court does not respect national law. If you change your constitution in your state, the Inter-American Court can say you have to change your constitution. Actually, the court has ordered 3 times for a state to change their constitutions according to their jurisprudence. But as I told you, I know miracles are coming in this case. We ask you to pray a lot for this case. The decision is coming this year, and it's going to be crucial for the Inter-American system. They didn't expect that El Salvador was going to defend so good and so hard in the hearing, and that had an impact on the judges. So please keep praying, and I know many of you are praying for the case. Please keep praying for the case and for the judges of the court, for they can convert and their hearts are touched and they realize what they're doing. This is Beatriz, like the communication strategy in this case. On the left, you can see the communication strategy of the petitioners. As you can see, no, Beatriz was a woman that faced Salvadorian state to save her life, no? And we had a communication strategy of showing Beatriz and her daughter Leliani, and it also had an impact in social media. I don't have social media, but I know it had a lot of impact in social media, and this is also very important with cases. We have to also work on communication strategies in order to advance in public opinion. Now in 2017, Amnesty International launched a regional campaign. Please let me know how many time I have, Robert, because, okay. Amnesty International launched a regional campaign called Niñas No Madres, Girls Not Mothers, in collaboration with Planned Parenthood, of course, aiming to promote access to abortion for girls who have become pregnant in Latin America. And also we have other 2 cases pending in the Inter-American system. One of them is terrible, which is the 17 plus, because these are actually women that were convicted for homicide because the kids were born. And many of them were killed. And still they are putting those cases as cases of abortion in the Inter-American Court. We already had one, which was the Manuela case. Dolores Gabriel was born. He died in terrible circumstances, and it was litigated as an abortion case. Right? So the Inter-American Court said this: if an infant is killed in the perinatal stage, the criminalization should be less. There should not be decriminalization, but you should not criminalize the same an infant that is killed. No? And you know the United States now is advancing in some, many of them have not prevailed, but still there are a lot of states that are saying that they are justifying the killing of newborn under the same circumstances that of abortion. So, of course, that it's like unspeakable, as Sean said, but that's what's happening. And we have these other cases also in the Inter-American system and in the European system. You know, the Down syndrome cases are very sad, and they are trying, the court, actually the European court said that women should have access to abortion because of the disability of the child. So, are there any opportunities in the horizon? Indeed, always. And we have to fight. We have to fight a lot and pray. And I think we have freedom of speech cases that should be litigated in our states and litigated in international courts. And we have all the chances to win freedom of speech cases. We have one now, Jim Demers versus Canada, in the Inter-American system that we're hoping to win. Jim Demers, it's an activist, anti-abortion activist who was arrested. He was also arrested and convicted, and we hope to win his case. And also right to protest. And there are other topics, different topics, like we have to shift to narratives that allow us to also use litigation on our behalf to defend our principles. So we need to delve, for example, in fetal pain and torture fetal pain and torture. That is something that we are litigating inside the states and also in the inter-American system. We need to build also on non-penal prohibitions, because the discourse is always centered on you want to imprison women, you want to imprison women. That is not true. But we also have to work in a narrative when we say, well, we are not going to, maybe not criminalize, but we're going to do other sanctions because this is not okay, this is evil. Selective abortion is another topic that we should shift narratives. Non-discrimination principle, surrogacy, in vitro fertilization, emphasizing prevention and access to information. And certainly, and I end with this, the most impactful instrument tirelessly cultivated here is the power of prayer. Devoting ourselves to pray is our earnest endeavor, recognizing that genuine miracles may be the only means now, in some instances, to safeguard the lives of 74 million unborn human beings that are killed in the womb each year. Thus, our heartfelt gratitude extends to you, and I extend my gratitude to you all, for in the grand tapestry of our change, it is you who are affecting tangible transformations. Thank you very much for your attention, and long live Christ our King.